I rise to speak on the Cognate debate with specific reference to the Corrective Services Promoting Safety and Other Legislation Amendment Bill 2024. According to the explanatory notes, the bill's purpose is to enhance the safety of frontline corrective services officers, victims of crime and the broader community. The bill includes provisions that will allow Chief Executive to revoke approval or place limitations on prisoners' personal calls, depending on the level of risk and other factors. Neither the prisoner or the individual affected would have any opportunity to have input into the Chief Executive's decision to suspend approval for the personal call to an individual. According to Queensland Corrective Services, QCS, these unlimited powers for restricting a prisoner's personal call is to ensure the continued safety and security of corrective services facilities in Queensland. Along the same lines, the bill greatly expands police powers, including the circumstances in which a police officer may enter a premises where a reportable offender resides, photograph a thing if a reportable offender is required to report information about that thing, and access a reportable offender's digital device. Under the bill, it will be an offence for a reportable offender to fail to comply with the requirement to give a police officer access to their digital device and its contents. The explanatory notes acknowledge that these amendments may be inconsistent with fundamental legislative principles and could result in self-incrimination. A number of submitters raised concerns over how broad the powers are. Legal Aid Queensland notes that the expanded powers have the potential for overuse or be abused with respect to a group of prisoners whose movements are already heavily monitored and restricted. LAQ also points out there is no requirement that the exercise of the power is reasonably necessary to monitor compliance with order. In relation to the expanded powers around accessing digital devices, LAQ observed that these provisions provide a blanket authority for police to access a device where it is not reasonably necessary to investigate the indictable offence under the order, and therefore unreasonably infringes upon the prisoner's right to privacy in circumstances where it is gratuitous. Deputy Speaker, the requirement for a researching officer to be the same sex as a prisoner is one of several safeguards in the current Corrective Services Act of 2006. The safeguard was originally introduced to protect the privacy of female prisoners, particularly given the intrusive nature of some searches. The current bill removes the safeguard, saying that a new principle of flexibility will be added to the requirements in subordinate legislation after the bill is passed. As the Queensland Human Rights Commission noticed, the benefit of increasing flexibility will likely be outweighed by a reduced level of legislative protections and reduced opportunity for input the drafting of regulations. The Commissioner expressed concerns over the use of regulation instead of primary legislation, saying that while there may be an intention to consult with stakeholders while developing the regulation in the first instance, the principle's removal from the primary legislation diminishes the opportunity for community input and parliamentary scrutiny of these issues. In the QHRC's experience, amendments to regulations are rarely subject of consultation by departments. And the Commissioner goes on to say that while a human rights certificate must be completed for subordinate legislation, the human rights analysis and parliamentary scrutiny is perfunctory. The bill also expands the use of body-worn cameras by corrective service officers to include when they accompany prisoners into public areas within the community. And as the Information Commissioner submitted, this expanded use of body-worn cameras should be subjected to privacy impact assessments. And the OIC has produced guidelines for agencies outlining the privacy impact and of information access obligations. Agencies must consider when implementing or expanding a camera surveillance system which includes body-worn cameras. According to the OIC, whilst the collection of personal information using these technologies may be considered necessary to ensure the safety and security of corrective service staff, prisoners and other individuals should be appropriately balanced so as not to intrude unreasonably into the personal affairs of those individuals. A PIA will assist to identify privacy risks and appropriate mitigation strategies. The OIC advised that a privacy impact assessment also needs to be updated at key phases throughout the life cycle of the implementation and the use of surveillance technology, including the passing of legislation and prior to the adoption of new surveillance technologies. The bill inserts new section 340AA into the Act to provide decision makers with the discretion to withhold details of information or reasons behind a decision information can be withheld if the decision maker is satisfied that releasing the information could reasonably be expected to cause harm, prejudice public safety or national security, prejudice the detection, investigation or prosecution of an offence, disclose the identity of a confidential source, or releasing the information is prohibited under another law. Again, all this is very broad, not to mention inconsistent with the rules of procedural fairness. The principle of procedural fairness, which is also known as natural justice, is one of the fundamental legislative principles specified under Section 4 of the Legislative Standard Acts 1992. Moreover, Queensland Judicial Review Act grants people advisory impacted by a decision the right to know the reasons for that decision. And currently, information may only be executed in cases where the Attorney-General has certified that disclosure of the information is contrary to public interest. The bill before the House will bypass this important safeguard by removing any need for a public interest assessment to be carried out by the Attorney-General. The proposed section also removes any requirement for the Attorney-General to keep a record of the reasons on which a decision to restrict certain information was based. This is clearly inappropriate. The absence of such requirement in the bill will significantly undermine the capacity of the courts to examine a decision as a part of judicial review proceedings. And the section is also incompatible with Queensland Human Rights Act, which states that a party to a civil proceeding has a right to a fair hearing. A number of submitters also expressed serious concerns that these amendments would greatly limit a prisoner's ability to respond to reasons for a decision. According to Prisoners' Legal Services, PLS considers that the proposed amendments undermine accountability and transparency in executive decision-making and fail to promote community safety, accountability, transparency and related rights are especially important in the context of a parole decision making, because these principles allow a prisoner to understand their responsibilities in relation to release and rehabilitation. The proposed amendments provide expansive discretionary powers for withholding details of relevant information for prisoners who are eligible for parole about why they remain in custody. As Legal Aid Queensland states, an information notice provided to a prisoner making application for parole order that refers only to confidential information as a reason for a substantial reason for a parole cancellation does not give the prisoner any information to which they can meaningfully provide a response. The practical consequence of this is that prisoners will remain in custody for longer because they will be unable to address any of the criteria used to justify.
Hello everyone, I'm Stephen Andrew, the State Member for Moranni. Thanks for watching, and don't forget to like, subscribe and turn on notifications to stay up to date with my latest videos. And also make sure to check out my other socials and my website links. They will be available in the description below. Thank you for joining us.